Today I'm going to talk about an effective dispute resolution in your contracts and how that can make your practices more profitable and less risky. Now, I know that when you're negotiating your contracts, your focus is on two clauses. What are the scope of your services and what are your fees going to be? And that's where they should be. But I can tell you from practicing and representing design professionals for over 30 years, an effective dispute resolution clause can be of critical importance when a dispute arises on your project. Now, some things that you might consider which will make your dispute resolution clauses most effective will be, number one, insist on a 60-day period of informal negotiations prior to any mediation. And why do I say that? Because typically architects and engineers are not litigious. They're typically not the plaintiffs. But if they are in a dispute as a defendant, then slowing down the race to the courthouse by the plaintiff, typically the owner, is something you want to strive for. And that can be done through a 60-day informal negotiation clause as a condition precedent to mediation. We all know that the second thing you're looking for in a clause is already in the AIA contracts. And I believe the AIA contracts are very, very good, but they can be made better and you can make them better. Now, in the AIA contracts, they have mediation as a condition precedent to the final dispute resolution clause. And that's something that is good, and it's another obstacle slowing down an owner who is chasing you to the courthouse. If you opt for mediation as a condition precedent, what happens then? If mediation is unsuccessful, where do you want your final dispute resolution to occur? And what I would tell you here and now, you as design professionals always want to opt for litigation over arbitration. Historically, the conventional wisdom was that arbitration is quicker and cheaper, and that's where people would want to be. But I can tell you time and time again, there are many, many cases that will demonstrate that arbitration can often last several weeks or even months in time and cost just as much as litigation. If mediation has not been successful and your case goes forward, where do you want your final dispute resolution to occur? I can tell you, after litigating cases for 30 years and representing design professionals, you want to be at the courthouse. You do not want to be in arbitration. I can tell you there are many more tools available to me as a lawyer representing you good folks in the design profession at the courthouse instead of an arbitration. Some of the reasons you may choose litigation over arbitration, in my experience, are as follows. First, you can have an opportunity to pick a jury, and you will have a judge. In arbitration, you have a panel, but there is no jury to pick from in an arbitration proceeding. Most importantly, I've tried enough cases to know that in litigation, you can get a complete defense verdict. In contrast, all too often in arbitration, there's a split the baby result where one party comes in demanding $1 million in damages, the respondent says zero, and lo and behold, 6 weeks, 8 weeks later, the arbitrator issues an award for $500,000. You want to be in litigation. You do not want to be in arbitration. And last but not least, if you don't like the result in litigation, you can take it up on appeal. Most states, at least once, maybe twice, depending on the jurisdiction in which you find yourself. If you try your cases at the courthouse, nobody pays a bill for the judge or the jury at the end of the trial, except through your ordinary taxes. In arbitration, I was in a 3-week arbitration proceeding where each side had to pay $150,000 to 3 members of an arbitration panel proceeding. These are some of the reasons why you would want to opt for litigation over arbitration. Okay, now another thing you should think in terms of is a fourth point that will make your dispute clause better. Routinely, you'll find owners want you to waive your trial by jury, which is given to you by right of our Constitution. I would suggest to you that on a project-by-project basis, you should strongly consider opting for a trial by jury. What are some of the reasons I would ask you to consider? You get a chance to pick a jury. You don't get a chance to pick a judge. The judge is assigned to your case. 2, you may think in terms of juries usually get it right. Sometimes judges get it wrong. 3, if you don't like the jury's decision at the end of the trial, you can make a motion to overturn it, whereas at a bench trial, if the judge decides a case, chances are that decision will be final. As a consequence, I would strongly urge you to consider those clauses to make your dispute resolution stronger. In conclusion, what do you want to do to make your dispute resolution clauses more effective and make your practices more profitable and less risky? First, you want to make sure you insist on a 60-day period of informal negotiations as a condition precedent to mediation. Second, you want to make sure you have mediation as a condition precedent to your final dispute resolution clause. Third, you always want to opt for litigation over arbitration. Last, you should consider on a project-by-project basis a trial by jury if you can get the owner to agree. If the owner will not agree, then I strongly encourage you to get something in exchange like a better limitation of liability clause. All of these provisions will help you make your practice more profitable and less risky.